Thank you, everyone, for joining us today. So as Pat said, my name is Greg Sunshine. I'm a public health analyst with CDC's Public Health Law Program. I've been with the Public Health Law Program for about 4 years. Next time you see me presenting, I'll be with Cherokee Contracting. They'll be my 4th contracting company in 4 years, which is always really exciting. But what's important to know is that in my time here at the Public Health Law Program, thankfully, my job hasn't changed. Since I went to law school, I have been focusing on public health emergency law through all of my studies and all of my experiential learning through internships and externships in my time at the University of Maryland. And right after law school, I actually had the really wonderful privilege of serving as a bioterrorism coordinator for the Baltimore City Health Department, and got to participate in some emergency response activities while I was with them. And so, emergency response and the law have been my life for the better part of making me do the math, at least the last 8 or 9 years of my studies, and I got to do some wonderful emergency response work too when I was in college. So I hope that through my presentation I can at least get you as excited as I am about the law and emergency response. At least that's my goal, is to have you leave this presentation interested in learning more about the role that law plays in emergency response, especially for your roles in labs, and hopefully convincing you that your attorneys aren't scary, that you should make friends with them, you should get in touch and engage with them. That's fundamentally important, and they're hopefully wonderfully nice people. You should totally invite them to lunch and get to know your lawyers. I want to start by introducing what the Public Health Law Program is. We serve to advance the use of law as a public health tool. That's our mission. What does that mean? That means that we want to engage with health department personnel at all levels of government, state, tribal, local, and territorial, as well as members of the public, as well as in our federal system as well. Engage with them, learn about the needs that they have when it comes to the law and their activities engaging in public health practice. And we want to convince them, teach them that the law is a really important fundamental tool. So how do we do that? We do what's known as legal epidemiology, which is the repeatable scientific collection of statutes and regulations and policies and analysis of them in a repeatable way based on protocols that anyone can follow to determine what impact those laws have on our public health system. That's what legal epidemiology is, using law to determine how policies and principles of the legal system can impact our health as a community through general day-to-day public health practice or through our healthcare system. We take the knowledge that we gain from legal epi and we develop it into training and workforce development, which is why all of you are here. We want to translate and make some of these possibly scary legal principles understandable and digestible for any kind of audience. So that's what our goal is. And we also want to help make partnerships and relationships, build good friendships between health department personnel and their attorneys and attorneys across state lines, because many states might be dealing with the same kinds of public health issues, and attorneys in those jurisdictions can really benefit from having good relationships, communicating, sharing knowledge. We have great standing conference calls with state public health attorneys and local public health attorneys talking about how they're facing similar issues and maybe going about addressing them in different ways. And they're always really fun, fruitful conversations, good collaborative nature, and we love that. And so when it comes to making those partnerships, it's not just limited to us talking to lawyers or us talking to health departments or connecting people. Folks in the field, if you want to get in touch with someone who has expertise in a certain area but might not be from your jurisdiction, let us know. If you have any questions at all, really, just let us know. Give me a call. You'll see my email address at the end of the presentation. It's gsunshine@cdc.gov. And we just want to be as helpful as we possibly can in any way that we can. There's no question that you can't ask us, but there is one thing, and that is we cannot provide legal advice. But don't let that stop you from getting in touch with us. If something kind of gets close to the line of what constitutes legal advice, we'll let you know. But really, that's really fundamental. And so, of course, we have to give a disclaimer because I'm an attorney, and attorneys love disclaimers. And what this basically says is that while I am an attorney, I am not your attorney. I'm going to be talking about a lot of different legal principles throughout this presentation, and some of them might be from your jurisdiction specifically, but that doesn't constitute legal advice. You have to talk to an attorney, tell them the specific facts of your situation, and they're going to take those facts, look at the law, and see how the law is going to impact your role, your responsibilities, the steps that you're contemplating taking. That's what legal advice is. So please feel free to reach out to us, but don't take anything that I'm going to say in this presentation as a substitute for getting in touch with your attorney about a legal matter. So there's a lot of really cross-cutting issues that I want to talk about today when it comes to considering the role of law in emergency response. I'm going to scare you briefly by talking about liability. I'm going to talk about some emergency response laws that are applicable to test sharing, mainly sharing across state lines. And then I'm going to talk about a really interesting analysis that our office and Temple University just completed on suspending legal barriers to emergency response and how those can be applicable to laboratory operations. All right, so the scary part, liability. What is liability? It is a breach of a duty. It is someone being held responsible because they didn't do something that they were supposed to do for someone else. It's violating a standard of care. And there can be many different kinds of standards of care. So we're going to talk about a few of them. We'll talk about general duties, medical malpractice duties, and then statutory duties. So general common law duty of care is the requirement that each person owes a duty to act as a reasonable person would under the same or similar circumstances. Now, in some instances, this general common law tort duty has been applied in the laboratory setting. And so I'm going to get a little boring, going to talk about some case law. I apologize. I'll try to make it as interesting as I possibly can. But in this case that you see right here on this slide, Elliott v. Lab Specialists, Inc., there was an employee, Elliott. He was fired from his job after a false positive drug test. Now, the laboratory contended that it didn't owe any specific duty to Elliott, to the employee. To protect, no duty to protect against the effects that can happen, like firing, for a false positive drug test. But what the court found was that under Louisiana law, a person's duty towards another person can be simply stated as the obligation to conform to the standard of conduct of an average reasonable man under same or similar circumstances. So how do we show that? How do we show what's reasonable? Well, most of the time that comes in the form of expert testimony. And so what the plaintiff did in this case was bring experts, two experts actually, that testified that the laboratory's protocol and methodology were scientifically inadequate and failed to meet accepted scientific standards, that it's the standards that you all set in the field that are going to establish that duty of care that must be followed. And so as a result, the court held that the laboratory should have conformed to those accepted standards of care, which would have prevented undue risks of harm, and they were found liable for the plaintiff's dismissal from his job as a result of that false positive drug test. Now, the general common law duty is different from a medical malpractice duty. Medical malpractice means that someone has to provide, a doctor has to provide the same type of care that a reasonably competent and skilled healthcare professional with the same or similar training and skills as that doctor. So a heart surgeon isn't going to be held to the same standards as a brain surgeon. They have different skill sets in the same or similar circumstances. So someone in that specialty, what they would reasonably be required or expected to provide, the type of care they would be expected to provide to a patient under the same or similar circumstances. Those same or similar circumstances are really important as a consideration when it comes to disaster response. No healthcare provider, and as you're going to see, laboratories can be considered healthcare providers, is going to be held to the same standards during a disaster as they would be held in a non-emergency circumstance. Understanding that the situations you operate in an emergency response are just by definition different. That's what a disaster is. The status quo of response, the way we provide services, does not work. It's not feasible because a disaster has stressed resources. It makes us unable to act in a normal way. That's what a disaster is. And so a healthcare provider like a lab who is providing services in a disaster isn't going to be held in terms of medical malpractice principles to the same standards as in non-emergency circumstances. Now, how can medical malpractice cases be different from just general common law tort cases? Well, it's really fundamental in terms of the standards that are going to be shown. So again, a similarly qualified health professional. Requirements for evidence. Certain levels of expertise are going to be required to show what a similarly qualified health professional would have done in those circumstances. Procedures can be different. Many states have medical malpractice review boards. And before you file a case in court, you have to go before this medical malpractice review board. And this board is either going to issue a recommendation as to whether the case should or should not proceed, or they're going to be able to award administrative remedies, fines that can be provided to a plaintiff if they are found to have had a duty that was owed to them violated by a doctor. In many of these instances, if you are found to be within the realm of medical malpractice, you have to go before one of those boards. And if you don't, your case can be dismissed because you didn't follow the proper procedures. It's really fundamental. And then also, for medical malpractice cases, the statute of limitations might be different. You might have 10 years to file a case under this general common law tort duty, but only 1 year to file a medical malpractice case. That's going to be really fundamental in determining whether a case can proceed. And then the last kind of duty that I want to talk about are statutory or regulatory duties. These are duties established by a law, statute, or a regulation. It can be referred to as negligence per se. If you violate this law, then you're necessarily negligent. Violation of this law shows negligence. Kind of the best way I can explain it, if you're driving along and you run a stop sign and you T-bone someone, you broke the law. You were supposed to stop at that stop sign. Not stopping at that stop sign is going to be negligent per se because you broke this law, which requires every person in our community to stop at a stop sign. It's going to be very, very, very easy to show that you're liable for T-boning that car because you broke that law. That's a statutory duty that's established. But when it comes to the clinical laboratory improvement amendments, compliance with those amendments doesn't necessarily constitute negligence. It can be used to articulate to try to prove negligence, but it doesn't establish a private right of action. There's nothing in CLIA that says that if you violate a CLIA rule, a person have the right to go to a court to seek relief, to get compensation for that violation. There is a right for individuals under a 2014 amendment to CLIA to petition a lab to get access to their records, similar to the kind of access that comes through HIPAA, but that's different from a right of action for negligence where someone can be awarded damages, something of that nature. So really important to keep in mind when we think about statutory duties and where CLIA falls into that. So when we think about who's responsible to individuals and responsibility equals potential for liability, we have to think about the actors, and that means both the laboratory itself as an entity and the individuals who are working within that lab. That means, will the entity be liable and or will the individuals be personally liable? We have some really interesting cases that contemplate the issues of laboratory liability. So in this first case you see here, the laboratory incorrectly reported that the plaintiff, the person who filed suit, had tuberculosis when she actually did not. She started treatment and that caused severe side effects. It turned out that the sample that was used was contaminated by using equipment that had previously tested other blood samples that were positive for tuberculosis. So when they went and retested the same sample but using different equipment, they found that she was actually negative for tuberculosis. So she sued for negligence, she sued for legal fraud, which she claimed caused emotional distress and economic losses. What happened, though, was that the court found that the laboratory fell within the definition of a healthcare provider or other healthcare provider pursuant to the Alabama Medical Liability Act. So we're dealing with the state of Alabama. And as a result, the plaintiff was required under those medical malpractice laws to provide expert medical testimony as to what the standard of care was and how that standard of care was breached to sustain her burden of showing that her case was justified. Unfortunately, during trial, the expert that the plaintiff brought hadn't practiced in the specialty of tuberculosis testing within the year prior, and that's one of the standards established in Alabama to determine what an expert is for the purposes of medical malpractice suits. And as a result, she was determined to have not been competent to give expert testimony concerning medical malpractice liability, and so the case against the laboratory was dismissed. So in this case, falling under that medical malpractice rubric was actually beneficial for the lab because it held the expert testimony requirements to a higher standards with which the plaintiff was not able to meet. So in the next case that you see here, plaintiff alleged that they contracted HIV from contaminated blood that they received during surgery, which was discovered 5 years after that surgery. So you can see this is a case by an individual against the American National Red Cross. So a year after this discovery, she discovered she had been exposed to HIV as a result of that blood transfusion. She sued the Red Cross and claimed that by not asking blood donors whether they engage in same-sex relationships, the Red Cross negligently failed to identify individuals posing high risk of being infected with HIV. And you can see this is a relatively old case back from 1993. The federal court dismissed the case, though, on statute of limitations grounds because they found that it was within the medical malpractice field. The action of drawing the patient's, drawing the donor's blood was found to be within the rubric of collection, processing, distributing human products that fell within the definition of medical malpractice. As a result, the shorter statute of limitations that applied in the state of Georgia for medical malpractice cases was deemed to be the statute of limitations, the time limit that they were actually considering, and so that case was dismissed. And then in another, one of the last cases I'm going to discuss as far as laboratory liability goes, involved a woman who was tested, her husband was tested for HIV to determine her risk of contracting the virus. After the sample was tested, the plaintiff was informed that he was actually positive for HIV. When they had the test privately examined by a private lab, they found that it was actually negative for HIV. The state who had originally tested retested, found yes, the negative test result was correct. So the plaintiff sued the state as a result of that original test and found and argued that there was extreme mental pain and anguish that they suffered as a result of mishandling or possibly mislabeling the first samples in the first test that resulted in that false positive result. The state argued that the plaintiffs first had to submit the case to one of those medical review panels that I talked about earlier because they were a patient, they were receiving health care as defined by the Act. The drawing of blood, the testing of blood was determined to be within the rubric of health care. And since they did not actually file that case with the medical review board beforehand, that case was dismissed. So you can see falling under general negligence or medical malpractice negligence can be really fundamental in determining how cases play out. But one last case that's not listed on here that I really want to talk about involved a case falling out of the rubric of medical malpractice. In Sander v. Gieb, Elston, and Frost Professional Association, there was a plaintiff's family who sued the lab as a result of the plaintiff's death from cancer. They argued that the laboratory that analyzed the patient's pap smears didn't catch the cancer until it was too late, until it had become terminal. What they argued was that the laboratory was found to have not followed procedures of having random quality checks by a pathologist. They kind of failed to have that standardized quality control to ensure that we're minimizing chances of mistakes like this one. As a result of this case, and the result of the way the laws were written in this state as to medical malpractice claims, the court actually found that since it was a laboratory entity that was being sued and not a natural person, a human being like you or I, the medical malpractice statute of limitations didn't apply, and as a result, the case was able to continue. And really fundamentally, you can kind of tell what's really important to these cases. Medical malpractice damage caps, which sometimes can be applied, didn't apply to this case, and so they weren't limited by the dollar amount that medical malpractice cases are limited to in the state because the laboratory was not a natural person and therefore didn't fall within those medical malpractice statutes. Now, Personal responsibility is probably a big fundamental concern for people that are on this. I imagine everyone who's paying attention to this webinar is an actual human being and not a corporation and entity. So personal liability is going to be a really fundamental consideration. So the first case I really want to talk about, Santos v. Kim. A child was born with severe brain damage and died one day after they were delivered by cesarean section. Now beforehand, the mother was known to be Rh negative. They performed blood tests on the unborn baby to determine whether there was any risk to the baby. The suit alleged that the laboratory, after conducting the blood test and getting the results, waited 2 weeks before they reported to the obstetricians. The test indicated dangerous levels of antibodies. Because of that 2-week delay, treatment, they claimed, was unduly delayed. They sued the obstetricians, the obstetrical group. They also sued the director of the Metro West Blood Bank and Hematology Laboratory, the person who is running the laboratory. And they claimed malpractice, wrongful conduct, breach of duty by the director of the lab. They claimed that it was his failure to institute practices and procedures that critical tests resulted in patients not getting notification promptly, or physicians not getting prompt notification from the lab. Now, the court looked at this case and found that the director's position as the person who's running the lab, who's the person who's establishing these standards, was not in and of itself sufficient to say that yes, that director owed a duty to these individuals, but that it said that it didn't necessarily, the fact that the director of the lab wasn't the one who was drawing the blood, the one who wasn't conducting the tests, that didn't necessarily absolve the director of the lab from liability either. And so as a result, the court was allowed to, the case was allowed to go to trial court, and they had a trial to determine whether or not that the director actually owed a duty to the lab. And in arguing that the director owed a lab, experts testified that the 2-week delay was indefensible. And as a result, there was a legitimate question of liability for this inquiry. And personnel at the laboratory specifically looked to the director to establish detailed policies and procedures to minimize the risks of harm as a result of tests that are being conducted and notification of results of those tests. The last case I want to talk about is Hansleman v. McCardle. In this case, a patient suffered from hematosis, which eventually caused respiratory and cardiac arrest. She died. The hospital and the individuals who performed the tests were sued. The claim was that they didn't follow laboratory procedures to ensure proper testing and to ensure immediate reporting of laboratory results. What the employees of the lab, which was a state lab, claimed was they were employees of the government, and therefore they were able to receive what's known as sovereign immunity, that as government employees, they could not be sued. The court found that sovereign immunity for these individuals who are conducting laboratory tests is a really fundamental question that can only be decided at trial. As a matter of law, state laboratory personnel in South Carolina did not receive protection because it depends on the tests that they were conducting and how they were conducting the tests. And that was only something that could be determined if the case actually got to court and they could have a trial to determine whether or not these individuals, these laboratory workers, would receive those liability protections as state employees. So a lot of really complex legalese there. I'm sorry for throwing all of that out to you. What matters? What's important? What are your takeaways? Policies, procedures, and protocols matter. You saw me say over and over again, or you heard me say over and over again, that someone or a person or a lab was found to have done a wrong, breached a duty because policies or procedures weren't properly implemented, or policies or procedures weren't properly established to be followed. That means that these policies, procedures, they matter. They're really important. They provide a blanket of protection. If you can show that you complied with these policies, that you followed this standard that was established by the field, that's going to give you a lot of protection if someone alleges that you did something wrong. Those policies have to be robust, clear, and updated. Personnel have to be trained on how to understand them, how to follow them. Failure to train could result in liability allegations against possibly the laboratory director or the laboratory itself. Personnel should read their employment contract. What's going to be expected of them? What are their duties going to be? Those employment duties could result in someone alleging that a duty was violated that caused an individual harm. Are you insured? Do you receive medical malpractice insurance as someone who works in a lab? And looking at standards of care, these professional standards of care are really what's going to be fundamental. This is what people are going to point to determine whether or not some duty was violated and whether you are now going to have to owe an individual compensation. And most importantly, talk to your attorney. Your attorney is going to help break down all these liability risks for you. They're going to look to see if there's any special protections that apply. When it comes to the field of emergency response, some states have emergency liability protections for individuals that are engaged in emergency response. An attorney can look at those liability protections and see in what situations do they apply and determine whether or not they apply to applicable individuals, whether it's someone who works in a lab. And then also there might be federal liability protections as well. The Public Readiness and Emergency Preparedness Act, the PrEP Act, provides a lot of liability protections when it comes to emergency response, typically in the realm of countermeasure distribution, but the way the PrEP Act is written, it also applies to diagnostics as well. So PrEP Act immunity, federal PrEP Act immunity could apply to a diagnostic test that's covered by a PrEP Act declaration. Let me know in the question section if you want to hear more about that. So let's talk about emergency response laws applicable to test sharing. The first thing I want to do is point out this URL. A lot of this information comes from this wonderful report, which is a policy guide for public health laboratory test service sharing. It's applicable to public health labs, so I understand if there are folks on the line that aren't working at a public health laboratory, maybe they're at a private lab, they might not see this as specifically applicable, but it's fundamentally important because it breaks down a lot of really common legal issues and policy issues that can come as a result of laboratories operating in situations where they are going to need to share services, whether that's a situation that's created by a disaster or a situation created just by a shortage of resources, funding mechanism, things like that. So think about going to this URL. It would be great if you could give it a read and see how it could apply to your lab. Some key things that you would find if you read this report that I'm going to highlight for you. Laboratories can look at a lot of different kinds of emergency response authorities when it comes to how their operations as a lab could be affected in a disaster. The laws of the jurisdiction can really fundamentally impact who is going to be in charge of the response, whether it's a state emergency management agency or a health department. Who's considered a responder? Does it have to be a state personnel? Can a responder be someone from another state? What resources can be used? What resources are needed for the response? How do we get them? How are they going to be requested? And once they're requested, how are they going to be provided? How can we get them? When can we get them? How long do we have to wait? So some really key elements to emergency response legal considerations are what's the definition of an emergency? State laws are going to define an emergency as a catastrophic event, some big bad thing that happens. It could affect a huge wide area, cause severe injury, loss of life, property damage. These are a lot of the kind of typical definitions of emergency. Things like natural disasters, hurricanes, tornadoes, or chemical attacks. Some states also have definitions for public health emergencies, and that could include disease outbreaks, appearance of an infectious agent that poses substantial risk to a community, whether intentionally distributed through some kind of bioterrorist attack or unintentionally through your run-of-the-mill disease outbreak. Some states will specifically tie certain legal mechanisms to these public health emergency declarations. For instance, in Maryland, the Catastrophic Health Emergency Act is only triggered by the presence of a chemical, biological, radiological disease agent. Absent that agent, the specific attributes of that Catastrophic Health Emergency Act won't apply. If you have a natural disaster, you don't get the tools that come with a catastrophic health emergency. So knowing the difference between the two can be fundamentally important. But not all states have laws that differentiate between an emergency and a public health emergency. Another key element is interstate emergency assistance, or even intrastate emergency assistance can be really fundamental when it comes to laboratory resource sharing in the context of emergency response. Some states and even some localities have entered into mutual aid agreements that authorize assistance to be provided across jurisdictional lines. This assistance could take the form of people, who work in the labs, or equipment, laboratory testing equipment. The services that are going to be provided are going to be determined by the laws of the jurisdiction and by those agreements themselves. Is this an agreement to share testing services only, meaning samples are going to be shared across jurisdictional lines? Is this an agreement to share testing capabilities, meaning that equipment can be sent across state lines if one state needs it during a disaster and another state is able to part with that equipment? Or does it apply to individuals? And then if it does apply to individuals, what kind of licensure, certification, reciprocity will there be? Some states like Maryland specifically authorize state and local public health laboratories to enter into mutual aid agreements with other states, and that applies in both directions, both providing and receiving assistance. And you can even click on this link right here to jump to that law. When it comes to planning for these disasters, there's a lot of really important considerations because the laws are going to differ and implicate how response can be provided. So some states empower the governors. It's the governor that can execute emergency mutual aid agreements. You've got these agreements in place, great. How do we use them? How do we activate them? You have to know who is the one who has the power to flip that switch. In a lot of states, it's going to be the governor. Some states condition on authority, the authority to share services on approval from the legislature. Legislatures in some states have to approve requests for resource sharing or certify these mutual aid agreements. Other states allow the adjutant general, the head of the National Guard, or directors of state or local emergency management agencies to enter into mutual aid agreements. Sometimes those have to be, though, approved by the governor. So how does this all apply to labs? Probably the best articulation of how emergency mutual aid sharing works is in the context of the Emergency Management Assistance Compact, which has been utilized by labs in the past for emergency response purposes. EMAC is an agreement between all 50 states and the District of Columbia and a number of territories to share resources across those state and territorial lines in the event of an emergency. It's a really fundamental agreement that has been established for years, certified by Congress, and then every state that has signed onto EMAC has actually, to use the legal term, codified the agreement, which means the actual text of the agreement was passed into law into every state. So EMAC is a compact, but it's also the law in every single state. It's a law that all states have agreed to follow when it comes to providing services pursuant to an EMAC request. So as a result, there's some really fundamental legal mechanisms in EMAC. Liability, what we just talked about for that whole section, that whole last section. States that are receiving assistance are going to bear the burden of providing liability protections. They're going to be the ones responsible for representing a responder if someone alleges that they did something wrong, that they breached a duty. But additionally, in every state's law, for personnel who are providing services pursuant to an EMAC request, immunity is provided so long as you're acting in good faith. We don't want to protect people from liability if they're not acting in good faith. If they are engaging in reckless or willful misconduct, we do not want to protect them from liability. As long as you're acting in good faith under an EMAC deployment, you are protected from liability. Reimbursement. This is a fun one. One of my favorite ways I've seen provisions written out in a law. Typically, operationally, states that are receiving assistance are going to reimburse the providing state. But the way it's written in the law, it says that the receiving state will reimburse the providing state, or the providing state will bear the cost of providing those resources out of the goodness of their heart, or an alternate agreement can be reached. So pursuant to EMAC, all reimbursement kind of mechanisms are legal under the compact, but typically, operationally, it's the receiving state that's going to reimburse the providing state. What is a fundamental issue is whether the services that are being provided are going to get reimbursement from the federal government if a Stafford Act declaration is provided. That's going to be a big, big deal in terms of capabilities providing reimbursement. And then really important in the context of labs, licensure and permit reciprocity. Personnel who are providing services in another state pursuant to an EMAC request are going to have their license and certification recognized in that state, even if they're not licensed in that state. That's what all the states agreed to when they signed on to the Emergency Management Assistance Compact, because personnel providing services is going to be very, very fundamental. So this is the law. This is the legal tool that we have to share services across state lines during emergencies. How does it look operationally? Do you think it's just the text of EMAC that exists and everyone just uses that compact to provide these services? Of course not. It's going to turn into paperwork and wonderful, wonderful paperwork. Mission-ready packages have been developed by the National Emergency Management Agency, or association. They are the ones who actually implement EMAC. They create model forms to request services, especially things like providing laboratory services or nurses, public health nurses, phlebotomists, things like that. They use the National Incident Management System's resource typing. We're going to talk about that in the next slide. But it makes it easy to request specific types of services. And it can require the mission-ready packages cover everything from start to finish. What the overall mission of the response or recovery are going to be, how you're going to articulate what resources you specifically need, how many of a certain type of individual, a person who has a certain skill that you need for response, how long they're going to be deployed for, and how much we expect costs to be. These are things that can be included in mission-ready packages. You can use a mission-ready package for preparedness, for understanding exactly what it is that you're going to expect to need if you need to share laboratory services across state lines pursuant to an EMAC request. But you still have to file a request for assistance. Again, another wonderful piece of paperwork. But using mission-ready packages can really help you get ready for those requests. Now, the National Emergency Management Association has a lot of great template documents that laboratories can use to build their own mission-ready package. And you can look at other types of mission-ready packages for other disciplines on this link right here. Really quickly, I talked about NIMS resource typing. Just a quick couple examples of certain resources and their types that are applicable to labs, laboratory technologists or technicians, ancillary support teams, which can include laboratory services, phlebotomists, and generators. If your lab is going to lose power, knowing that you can request generators through EMAC from another state can be fundamental. And so EMAC was used extensively by the Louisiana Public Health Laboratory during Hurricane Katrina. This is a really great EMAC success story when it comes to the context of laboratories. We had Alabama providing bioterrorism testing in case of a white powder event. Arkansas did their drinking water testing pursuant to EMAC. Iowa did the newborn screening. Texas did drinking water and additional drinking water and TB testing for Louisiana. Then also the federal government was able to provide mobile testing resources in Hurricane Katrina because of the Public Health Laboratory in Louisiana getting knocked out by the storm. So great success story. You can learn more about it at this link right here. I'm going to go through this last section relatively quickly because I want to leave a lot of time for questions and answers. Suspending legal barriers to laboratory operations during an emergency. So laws can govern a lot when it comes to what a lab does, requiring certain certification for staff, accreditation requirements. I know that New York has some of the most stringent laboratory accreditation requirements, exceeding even that of CLIA. So knowing that the state law can really impact how a lab operates is fundamental. That can also impact how that lab in that state can share or receive assistance with another state. Law is going to determine privacy information sharing requirements, and then also the big one, procurement, payment, reimbursement. Can't do anything if we can't pay for it. Laws, the principle of laws is they protect communities, enforce welfare, morals of a community, but during a disaster, when we have a response, when we have an emergency bearing down on a community, sometimes those laws could hinder a response, and they actually might do more harm than good. So some states have actually granted governors the power to change laws during an emergency to remove those legal barriers. So that can be activated through the declaration of an emergency. Really, an emergency declaration is a power granted to an executive official, typically a governor, by a state legislature to declare an emergency and change the legal landscape, activating certain powers, which may include the power to suspend certain statutes and regulations. So we conducted a legal epidemiological assessment to determine what states have these emergency suspension powers. The primary researchers were Kelly Thompson and Nick Anderson, two wonderful attorneys who did this research. You can click this link or the image to go to the actual analysis to see how the states break out in terms of suspension powers. Feel free to play with that after the presentation is over. But here are the results. So you can see some pretty good coverage with these kinds of laws. 42 states explicitly permit the governor specifically to change statutes or regulations during an emergency, either statutes or regulations. Now, I can tell you that a lot of laboratory rules are going to be established by regulation, but not all. Some might be established through statutes. So the next slide is really important. Only 35 states specifically permit governors to suspend and amend both statutes and regulations. In this state, there are some that differ that only allow, in this map I mean, that only allow regulations to be suspended. And we're going to see how it breaks down. But in these 35 states, if something is established through law, through a statute that governs laboratory operations that might inhibit response, in these 35 states, that can be suspended. So here are those 7 states where the ability to change law during an emergency is limited just to regulations: Idaho, Minnesota, New Hampshire, Oregon, South Carolina, South Dakota, and Wisconsin. That means in those states, if a standard that governs laboratory operations that's getting in the way of response is established in a statute as opposed to a regulation, which is an agency-made rule, those requirements might have to stand. They can't use that governor emergency suspension authority to remove those statutory requirements. They're limited to only changing regulatory requirements. One state, in the way it's articulated the language of that power, North Carolina, allows governors to create new statutes and regulations, so not just suspend barriers, but maybe we can think of hurdles or chutes and ladders. That's a great analogy that I just thought of. In some states, suspending rules will get rid of those ladders that you normally have to climb up, get over to address a legal requirement. But in North Carolina, new statutes or regulations can be created, which might make things easier. So we'll call it a chute, where you can slide down and cruise on through with your response because of a new statute or regulation that was created. And then 2 states permit the creation of regulations, but not statutes, to address emergency response: Minnesota and New Hampshire. Now, 9 jurisdictions don't have any specific statutory authority for governors to change statutes or regulations during emergencies. That's Kentucky, Massachusetts, Nevada, New Mexico, Ohio, Vermont, Virginia, Wyoming, and the District of Columbia. This means that these states haven't established an affirmative duty for the governor specifically to engage in a large breadth of emergency suspensions of statutes and regulations to respond to a disaster. As a result, they have to rely on other legal arguments or mechanisms, emergency rulemaking through a state Administrative Procedure Act, or getting a waiver from a state licensure board to overcome different kinds of legal barriers that could inhibit your response. How have these suspensions been utilized in the past in ways that we can analogize to laboratory operations? No suspensions in our analysis of over 300 emergency declarations were specifically applicable to labs, but we can analogize some of these past suspensions to things that are fundamental to laboratory operations. California, during H1N1, suspended contracting and bidding requirements in the waiting period for emergency appointments. So we could appoint new state employees to respond to the H1N1 flu in California without the typical waiting period and the typical contracting requirements. In Ohio, also during H1N1, purchasing and contracting requirements were suspended. That allowed items, equipment to be procured quicker, faster than is normally allowed, and suspended state Administrative Procedure Acts to create new regulations to allow for Medicare reimbursement for physicians' offices who are administering the vaccine. Arkansas suspended provisions prescribing procedures for conduct for the State Office of Personnel so that personnel could render maximum assistance. So the procedures of conduct that normally govern what state employees are allowed to do on a day-to-day basis were suspended so they could have a broader role in the response to those tornadoes and storms. New York, during the 2013 seasonal flu, suspended laws to allow pharmacists to vaccinate children between 6 months and 18 years. Normally, it's only 18 years or older. So you can think of that as expanding the scope of practice. If your lab is governed by a law that limits what certain personnel can do based on their certifications, in response to an emergency, it might have to be all hands on deck. So using this kind of suspension could expand the scope of practice of that laboratory personnel. And then in that same response, the New York 2013 seasonal flu suspended laws that allowed health officials to include adult immunization information into their immunization information system without getting that person's consent first. So information requirements, which can be very, very applicable to labs, can be waived through these suspension authorities. So think about how these can be analogized, like I said, to laboratory operations in the context of emergency response. All right, so quick conclusions. Liability is really, really fundamental for both the lab as an entity itself and the individuals. There's a lot of protections that can exist, but really nothing is more important than making sure your policies and procedures are updated. You've trained on them so you can show if you are sued that you did not violate that standard of care. The Emergency Management Assistance Compact can provide a lot of resources when it comes to laboratory operations in the context of a disaster. And that's really going to be helpful in procuring both personnel and resources when it comes to sharing test services when responding. And then finally, state statutes and regulations that affect laboratory functions, laboratory operations, such as procurement requirements for laboratory equipment, can hinder the response to a disaster. And so some states have the ability to declare emergencies and remove those barriers when it's necessary for that response. So that's it for me. A lot of information. I want to give a special thanks to Emily Sargent, who is a wonderful intern for the summer, provided a lot of great assistance in the development of this presentation. So special thanks to Emily. And I really want to take the opportunity to take questions from all of you. But if time runs out, feel free to contact me at my email address here. All right, thank you.
Gregory will take questions from our audience. If you will type your questions in the chat room, and so we will start asking questions right now. Let's see. Yeah, please explain more in regards to the PREP Act.
The PrEP Act, the Public Readiness Emergency Preparedness Act. You followed my request to ask a question about the PrEP Act. So the Public Readiness and Emergency Preparedness Act was passed to provide liability protections for someone who is involved in the provision of emergency countermeasures. That means the manufacturers, distributors, that means the administrators of emergency countermeasures. PrEP Act declarations have been tested in court surrounding the 2009 H1N1 vaccine and are found to protect individuals from liability when they're alleged to have an injury is alleged that's connected to a covered countermeasure. Now, that's just one federal authority that relates to countermeasures. FDA has a number of authorities: emergency use authorizations, investigational new drug approvals, emergency dispensing orders. Those are different. During the Ebola response, we saw emergency use authorizations issued for in vitro diagnostics for detecting the Ebola virus. We saw emergency use authorizations issued for Ebola vaccines and therapeutics. When it came to the PrEP Act, we saw PrEP Act declarations, liability protections issued for those Ebola therapeutics and vaccines, but we didn't see any PrEP Act declarations provide that immunity for the in vitro diagnostics. But that should not be interpreted to mean that diagnostics aren't covered by the PrEP Act. They are. The PrEP Act allows immunity protections, federal immunity protections for anyone involved in the distribution of these countermeasures to be protected from liability if they're engaged in the development, use, or administration of a covered countermeasure. The key, though, is a PrEP Act declaration specific to that countermeasure, which can include those diagnostics.
How can we find what the specific EMAC is for our state? All
right, so everyone in every state has the same EMAC. It has the same Emergency Management Assistance Compact. The text of EMAC is this one standardized agreement. That's the text that Congress approved because it was a compact between states which require congressional approval under our Constitution. And all states who signed on to the agreement, signed on to EMAC, signed on to the exact same terms. When you Google EMAC, and you can look at the text of EMAC on emacweb.org, that is the text of the agreement. That's what's been established in law in your state. Now, I do have to say, a lot of states have also passed there are additional different emergency management assistance compacts between other states and actually other territories as well. So there's IEMAC, the International Emergency Management Assistance Compact, which involves those northeastern states and provinces of Canada in that area. And then there's PNEMA, the Pacific Northwest Emergency Management Arrangement, and that's kind of the opposite coast. That's the northwest states and provinces of Canada in that area. But even with those two international emergency management agreements, they use basically the exact same text as EMAC. All these agreements can be found easily through Googling, so please check those out.
Okay. Is there a mechanism for discussion between attorneys skilled in EM law with a healthcare organization attorneys?
Yeah, there's a lot of options available to you. So the first one you can do is you can get in touch with us, and we can have a conversation between the subject matter experts on emergency response law in our office. It'd be myself, the director of the public health law program, Matthew Penn, and a number of other attorneys have a lot of expertise in this area. We can have those conversations with healthcare attorneys. We can also help connect you with attorneys from the Network for Public Health Law who work specifically in emergency management, or we can actually connect them with the attorneys who represent the health department in your jurisdiction who cover emergency response activities. We are connected and plugged in with those attorneys as well. Or if they want to talk to just folks from other jurisdictions, we're always happy to start those conversations.
Does EMAC declarations have to have a limited defined duration?
Yes and no. Well, the deployment of the resources has to have a defined duration. Emergency assistance provided through EMAC can only be provided so long as that response has been activated. An EMAC request during a disaster can't be initiated until the state has declared an emergency. So that's going to be really fundamental. But some of the resources can be extended beyond. But as far as the resource requests pursuant to that system, the EMAC system, there has to be a time that's going to be defined and agreed upon by both parties. That's just a matter of negotiation, having those conversations ahead of time. But EMAC also contemplates the provision of assistance for preparedness activities as well. So states can utilize EMAC to help with exercises and things like that across state lines.
Does the CDC provide legal advice to state attorneys providing legal advice for state public health laboratories?
This is an easy one. No. The CDC cannot provide legal advice to anyone, so I'll back up. I'm in the public health law program at CDC. We are the CDC's other office of attorneys. The office that represents CDC that provides legal advice is the Office of General Counsel. Public health law program, we serve as any other scientific office at CDC. We provide subject matter expertise on certain issues. For us, they're legal issues, but it's just expertise. We can provide assistance, we can provide resources, we can give some of our expertise, but when it comes to actual legal advice being provided at CDC, that's the Office of General Counsel. And when the Office of General Counsel is providing legal advice, that can only be for CDC operations by the organization, the entity itself, or the official duties and responsibilities of CDC personnel. Unfortunately, only your state public health lawyers who are representing your state public health laboratories can provide legal advice.
Does EMAC require disclosure that services are provided under these emergency suspensions?
No, it does not. Actually, EMAC doesn't contemplate emergency suspensions at all. EMAC operates to actually remove a lot of the need for those suspensions. So you would utilize emergency suspensions if you want to expand your own state's scopes of practice rules so that doctors in your state could do more, or let's say pharmacists could vaccinate more people in your state. But when it comes to recognizing another state's licensure and certification, EMAC serves to remove that barrier. But the important thing to know is that EMAC only applies to state resources. So you can only deploy personnel pursuant to an EMAC request if they're a state employee. Some states have legal mechanisms to deem non-state employees as state personnel for the purposes of emergency response, and then they could be deployable personnel. But when it comes to EMAC redeploying resources or personnel, none of it's going to be conditional on those suspensions. That's not included anywhere in that agreement.
Is there a legal gray area when developing emergency plans to scale back services as a result of a disaster affecting the testing facility?
If I understand, the question is if there's a statutory duty for a state public health laboratory to provide certain kinds of testing services, let's say newborn blood screening, but a disaster hits and that facility is no longer, the state public health lab is no longer able to provide newborn test screening because they don't have the capacity because of that disaster, are they violating the law? Are they going to be held responsible? That's really going to be situationally dependent, depends on the way that law is written, but sharing resources like newborn blood screening across different states happens all the time. Many states, especially in the Pacific Northwest, do not do their own newborn blood screening. They contract out to neighboring state public health laboratories to provide those services. That kind of test sharing can be a way to show that you are still providing those services that are mandated under law, just not directly, but the services are still being provided to the citizens of the state. So I hope that answers the question.